The justices have determined whether U.S. gun manufacturers can be held liable for crimes committed outside of the United States by Mexican drug cartels.
So another unanimous ruling from the Supreme Court, this one by Justice Kagan, a liberal on the court.
While the world was distracted by political theater and celebrity gossip, something historic shook Washington, D.C., and hardly anyone noticed. Without fanfare, without even mentioning the phrase gun control, the United States Supreme Court issued a ruling that legal experts are calling the most devastating blow to state-level assault weapon bans in American history, a unanimous 9-0 decision, liberals and conservatives on the bench together, speaking with one voice. And yet, the mainstream media barely whispered about it, but buried inside those pages was a single sentence, just one, that could unravel decades of restrictive laws in places like California, New York, Illinois, and Connecticut. It didn't look like much at first glance, but in reality, it was a constitutional earthquake, the case nobody expected. It all began in 2021 when the Mexican government filed a lawsuit against some of the biggest names in American firearms manufacturing: Smith & Wesson, Glock, Colt, Ruger, and more. Their claim was extraordinary, that these companies were fueling cartel violence by allowing firearms to be trafficked across the border. Mexico didn't accuse them of breaking U.S. laws directly. Instead, they argued the companies should be held responsible for crimes committed by third parties, the smugglers, the dealers, and ultimately, the cartels themselves. The price tag, over $10 billion in damages. It was a bold legal gamble, almost a Hail Mary. The Mexican government was essentially trying to use American courts to make U.S. companies pay for violence outside the country. The case made headlines worldwide, and when a U.S. district court dismissed it, citing the Protection of Lawful Commerce in Arms Act of 2005, many thought it was finished.
Back here in the U.S., the U.S. Supreme Court is hearing arguments on a $10 billion lawsuit Mexico filed against U.S. gun makers. The Mexican government tried to hold U.S. manufacturers like Smith & Wesson and Interstate Arms accountable for their part in supplying weapons to drug cartels in their country.
That law was designed to protect gun makers and sellers from liability when their products are misused by others. Just as you can't sue Ford because someone drove a car into a crowd, you can't sue a firearm manufacturer because someone misused their product in a crime. But Mexico appealed, and against all odds, the case climbed its way up through the courts. By June 2025, it landed in front of the 9 justices of the Supreme Court, a 9-0 earthquake. When the decision came, it stunned everyone. In a rare display of unity, all 9 justices sided with the gun manufacturers. The ruling was clear: foreign governments cannot use American courts to punish U.S. businesses for crimes committed by others abroad. But hidden inside the text was a line that no one expected. Justice Elena Kagan, writing for the court, included a statement that may have just detonated every state assault weapon ban in America. The line read, "Firearms like the AR-15 are widely legal and commonly owned by law-abiding citizens for lawful purposes." At first glance, it looked like a simple observation, but legally, it was dynamite.
Essentially, the gun manufacturers did not do enough to be liable under the statute. There's actually, the statute itself gives virtual blanket immunity to gun manufacturers, except in certain specific cases like aiding and abetting. The court just said it's all too distant. You can't tie what the gun manufacturers do to the violence in Mexico in a way that under this statute is fair to impose liability on them.
Why that sentence changes everything. Under previous landmark rulings, District of Columbia versus Heller, 2008, and New York State Rifle and Pistol Association versus Bruin, 2022, the court had made one thing clear: the government cannot ban weapons that are in common use by law-abiding citizens for lawful purposes. That standard, known as the common use test, is now the backbone of modern Second Amendment interpretation. And Justice Kagan's line didn't just repeat it, she applied it directly to the most controversial rifle in America, the AR-15. Think about what that means. The Supreme Court has now gone on record, unanimously, to say that AR-15 style rifles are both common and lawful. That finding doesn't exist in a vacuum. It has immediate consequences for every state that has tried to outlaw them. Numbers back this up. According to the National Shooting Sports Foundation, over 24.4 million AR style rifles are currently owned by civilians in the United States. That's more than the number of Ford F-150 trucks on American roads. These rifles are used for home defense, hunting, sport shooting, and competitions. clearly lawful activities. So when the Supreme Court says these firearms are widely legal and commonly owned, it's not just commentary, it's precedent, and it undercuts the very foundation of every so-called assault weapon ban in the country, the domino effect. Almost immediately, attorneys across the country began citing this ruling. In California, where the strictest bans have been in place for decades, lawyers are walking into courtrooms armed with the Supreme Court's own words. Cases like Miller versus Bonta, which already challenged California's Assault Weapons Control Act, have now become constitutional battering rams. Judge Roger Benitez previously struck down parts of the law, calling it unconstitutional, but with this Supreme Court decision, challengers have even more ammunition. The argument is simple and devastating. The Supreme Court has declared these rifles lawful and common. Therefore, they are constitutionally protected. States cannot ban them. If the highest court in the land recognizes AR-15s as legitimate and widely used, how can a state justify banning them? The logic is airtight, and the legal dominoes are already starting to fall. The opposition in disarray. Not everyone is taking this quietly. Gun control advocates, politicians, and even judges are scrambling to defend their bans, and their arguments are starting to sound desperate. During recent hearings, some Ninth Circuit judges appeared shockingly uninformed. One repeatedly referred to AR-15s as machine guns, despite being corrected multiple times. Another called them a 15S, unable to even pronounce the name of the rifle at the center of the case. Even more alarming, some floated the idea that constitutional rights could vary by state. Imagine a world where your freedom of speech or freedom of religion depended on your zip code. That's the level of reasoning now being used to defend these laws. These stumbles aren't just embarrassing, they reveal how fragile the anti-gun legal strategy has become. When confronted with the Supreme Court's crystal clear declaration, their defenses crumble. Beyond California, this isn't just about California. Right now, 10 states and Washington, D.C. have some form of assault weapon ban. They use similar definitions, targeting rifles with features like pistol grips, adjustable stocks, or flash suppressors. But compliance with these laws has always been shaky. In Illinois, a 2023 ban affected millions of lawful gun owners, sparking lawsuits almost immediately. In New York, fewer than 15% of affected firearms were ever registered under the SAFE Act. In Connecticut, out of hundreds of thousands of rifles, only a fraction were registered during the compliance window. The reality is that these laws don't reflect actual ownership patterns. Millions of Americans own these rifles, and they use them responsibly every day. Now, with the Supreme Court's unanimous ruling, judges across the country are being forced to confront that reality. What comes next? So what happens now? Expect a tidal wave of lawsuits. Cases in Illinois, New York, Maryland, New Jersey, and other states are already being filed or revived, each one pointing to the Supreme Court's ruling as a constitutional sledgehammer. And this isn't just about AR-15s. The precedent extends to any firearm that can be shown to be in common use. From handguns to semi-automatic shotguns, the scope is broad and the implications massive. Politicians may try to fight back with new definitions, new restrictions, or by labeling vast swaths of public areas as sensitive places. But these tactics are temporary. The court has already drawn the line. If it's commonly owned and lawfully used, it's protected. Period. The bigger picture. This decision marks more than just a legal victory for gun owners. It's a fundamental shift in the way the Constitution is being applied. For decades, gun control advocates relied on optics and emotion, painting certain firearms as inherently dangerous, regardless of how many Americans owned them. That strategy just collapsed. The court has said with one voice that popularity and lawful use matter. You can't erase millions of Americans' rights with a pen stroke just because a weapon looks scary or because it's been misused by criminals. This is about more than rifles. It's about the balance between freedom and control and whether constitutional rights can be chipped away by state-level politics. The Supreme Court has now declared they cannot. The turning point. Looking forward, this may be remembered as the moment when the era of assault weapon bans began to end. One line and one ruling has set off a chain reaction that could topple laws across the nation. It's not just a victory for manufacturers, it's a victory for millions of ordinary citizens who, perhaps unknowingly, were holding in their hands the very proof of constitutionality, the fact that their ownership was widespread, lawful, and protected. The question now is whether states will accept this new reality or continue to resist, dragging their citizens through years of futile legal battles. Either way, the tide has shifted, the foundation has cracked, and the weight of the Constitution is bearing down on laws that once seemed untouchable.